Okay, let's get started. This next panel is going to be a conversation about copyright, copyright law. I'll fill you in a little bit on my thought process of putting this together. This, which I know some people have been critical of me, this is not intended to be fair and balanced. This is intended to be the perspective of content creators. Okay, so we have a bunch of folks here who work with content creators, and we can have a fair and balanced conversation some other time. But a lot of what we do, IPWatchdog was founded on standing up for creators, inventors, artists. And so if you have any problems with me having a conversation about copyright law from the content creator's perspective, I really don't know what to tell you. Because we're going to have that conversation here today, and we have really an all-star panel, and I'm really happy to introduce everyone to you. Let me start by introducing with the audience left, Susan Chertoff, and she's Senior Vice President of Legal and Regulatory Affairs from the Recording Industry Association of America. And then next to Susan, we have Reagan Smith, and she is Senior Vice President and General Counsel of the News Media Alliance. And next to Reagan, we have Terry Hart, who is the General Counsel of the Association of American Publishers. And last but certainly not least, we have Professor John Guerin, and he is a professor at Nova Southeastern University Shepherd Broad College of Law and the director of the Goodwin Program for Society, Technology, and Law. So what I want to do is have a conversation about a couple things. One is the copyright laws and that sort of thing, the cases that are ongoing. But I also want to make sure we get to literally, the whole reason for doing this is to get the perspective of content creators who are, I think, just unfortunately always on the short end of the stick, and particularly in the area where we're talking about creating and making a living off of creating is getting much more difficult to do for content creators. And so I want to just shine some spotlight on that and get that perspective out there. But what I'd like to do is start, as we've done with all the panels so far, and we can go in the order in which I introduced you. Susan, let's begin with you. What is it that you would like people to have at the top of their mind as we begin this conversation today?
Well, the topic that I understand we're supposed to be focusing on is fair use, and on that topic, I think the key point is that fair use, there's nothing categorical about it. And if you look at the arguments that have been made in this space by the AI companies and their advocates, they want to pretend that there's all these bright line rules, that there's such thing as a non-expressive use exception or things like that. And there aren't those kind of bright lines. Fair use is a case-by-case balancing test, and I think that the courts are going to come out finding that what the AI companies are doing by ingesting copyrighted works is not fair use.
Okay, great, thank you. Reagan.
I would build on what Susan is saying and say that when we talk about fair use in some of these cases that we're seeing, debated about and litigated in courts and discussed about in policy forums, a lot of the principles of fair use are really not favorable for some of the hoovering up of content we've seen on this massive, massive scale. And so I'm here today representing the media, which a lot of the media material almost, goals of almost all of the media material have been hoovered up in these LLM uses. And I also want to make a point of how dangerous that is to the incentive to create and produce these materials when we're taking something, using it to have a substitutional product in the market. So AI can take journalistic content and creative content, and can threaten it, but it's not going to be able to replace it to generate new works in the first place, because that does take humans and human journalists and investment and support of newsrooms going out there being the watchdog, where we're here as a type of watchdog, right? But that is an important role that we've had in our society and in our democracy for centuries, and so it's very concerning to see the sort of disregard for respecting the traditional lines that we've seen in our copyright system.
Great, thanks. And Terry, your preliminary thoughts?
Yeah, thanks, Gene. I'd like to start with, I think, a basic premise that I keep in mind when I think through these fair use arguments and the fair use discussion. This is really high-level principle, but I think it's really a really critical one to kind of setting the groundwork, and that's this. And I'm talking specifically about generative text models, because that's the ones that I do a lot of thinking about. My members produce and publish books and educational materials and scientific and scholarly journal articles, and all of those materials are highly valuable for training AI models, specifically large language models, generative text models. And so the basic premise is that regardless of the output of these models, and we see a lot in litigation these examples of these generative models that are being sued, examples where the output is either verbatim copying of the training materials or substantially similar in some fashion to the training materials. Setting that aside, and I don't want to suggest that that's not important, but just on the input side, even if these models were able to be tuned or programmed so that they never or very rarely will output something that's actually, in the copyright sense, substantially similar or infringing on the input materials, the copyright owners are still, in my view, entitled to the value that these models are generating, because their works are serving as the foundation of those models, and they're creating that foundation upon which the models generate the additional value. And so that's, to me, is what I have in mind as the starting point. And going beyond that, I think it's really the marketplace that determines, well, how both parties come with different ideas of what that value is, and they could work that out through licensing, through negotiations. But really, for me, that starting point is the key point.
Great, thank you. And John?
Sure, thank you. And first, thank you for inviting us. It's been a really interesting day. I want to take it a step more abstract, right? When we talk about intellectual property, of course, there are 5 rights, and we've talked about patent. We're going to be talking about copyright. Trade secret was mentioned earlier, but trademarks to a certain extent and rights of publicity, I think, are also very important, and they tie directly into the copyright conversation because of our failure to properly amend the 76 Act when we joined the Berne Convention and fully recognize rights of attribution and integrity. And so now we're seeing that 1986 failure come to roost. And so if we look at the harms that happen to creators, it's not just that their works are being used, but they're being used without their name, which diminishes the value that they get. They're being used in ways that they don't approve, which raises issues of integrity. And so I really think that we need to think about the people who are the creators and the artists and realize that through a series of choices, we've really undermined the creative community. And whether that's journalism, publishers, filmmakers, musicians, we really have taken a series of steps beginning in '86 that have led to a shrinking of that economic economy. And that's really the core of the creative economy that the United States runs on, and so we need to reinvest in it.
Great, excellent preliminary thoughts. I want to get some more preliminary thoughts from me to lay the foundation of what conversation I want to have. I hear just some truly outrageous claims made by the AI developers about how this is not copyright infringement. They say, fair use. They also say it's not copyright infringement. They also say things like, well, we're not copying the expression, we're copying the facts, which actually, it's precisely, if you understand how the AI works, it's precisely looking to filter out, take the expression. And one of the things that I did in preparing for this conversation and in dealing with some of the arguments I've had with people, civil arguments, they weren't like fisticuffs or anything, but with the other side was I went to ChatGPT and I asked it, I said, write me a brief story about what AI is so it sounds like Dr. Seuss. Okay, now they'll tell you they do not copy expression. But I got a Seussian tale of what, I won't read the whole thing to you, but part of it says, AI love to learn, oh, what a spree, from every bit and byte to infinity. And it goes on from there in a very Seussian way. So if you're not copying the expression, how could you possibly provide Seussian expression, right? I mean, so a lot of these arguments I don't think they pass the sniff test, and I'd like to have that conversation today. The other thing that I want to talk about, and maybe Susan, this is good to bring you in and ask you to comment on this, is a lot of people will say, and I think that there's probably a lot of people that believe this, and I just don't think they know the industry. They liken AI to, well, it's learning. It's just the same as music sampling. People can make music based on samples that they use from other people. And the answer was yes, but somebody's getting paid for that, right? And that's one of the big, huge problems here. It's not what, John, you were saying, some people don't want it at all, don't use my stuff at all. And others are like, well, you could use it. I just want to get paid for it. Where in the music sampling space, they do get paid, right?
Exactly, and I think I would say yes, it's just like music sampling. We have licensing departments that spend all day, every day issuing licenses for samples and acquiring licenses, depending whether you're using someone else's work as a sample or you're the owner of something that's being sampled. And licensing works. There's all sorts of uses of music in the world today that were novel when they first came out. There's social media, there's TikTok, there's a fight over TikTok at the moment, but there's TikTok, there's Facebook, there's Spotify, there's YouTube, there's all manner of sort of new uses that technology brought about that the music industry has found a way to license in the free market and is doing so very successfully. And AI is no different. AI is just the newest technology on the block, and it should follow the same playbook that all these other new technologies played. Yeah.
And Reagan, from the standpoint of the news and journalism and stuff, what is your response to things like, well, we're not taking the expression, we're just taking the facts?
Yeah, it's it's highly concerning because the news business is built on, expressing the facts and having journalists and writers write the facts, and that's copyrightable expression. That's a foundation of our copyright law. And it's true, everyone can go out and bear witness and write their own facts, and there are certain facts that are not protectable, but that has never been interpreted as if journalistic content was just free for the taking. And so what News Media Alliance did was we investigated into it, and then we reported on it. So we had a white paper that looked at whether the facts or the expression was being copied, and that was one of the items we looked at. And it's not just, as Terry pointed out, that when the guardrails are kind of loose, you can get all these verbatim regurgitations of things, and that kind of shows you that something is stored in the model. But the process of training an LLM typically makes tons and tons and tons of copies, and you can see this in submissions all around the world by AI technology companies, and the fact that you're making those copies for training is not even in dispute. When you look at what goes into the model itself, that was part of what we focused on, the process of encoding and looking at the strings of words together. It's not just one word or the other. They are able to come back with verbatim reports of giant pieces of text, and this has been reported by 404 Media. This has been reported by Northwestern University's Journalism Institute. Some of these are documented in our white paper, and this is even some who thinks this, professors of copyright law who think this should be fair use, say, hey, we have to start grappling with this problem that we're seeing a lot of this use is expressive in nature. And so taking just the facts is is not really supported by what we're seeing here. And one last illustration of this is something called the reversal curse. So if you're just learning facts or you're learning about something, you would think that you could learn if A is B, B is A, and that's not what these models do. So the example we gave in our paper was, who is Tom Cruise's mother? And ChatGPT can tell you that. And then if you say the name of the woman, they can't say, well, that is Tom Cruise's mother. It doesn't go the other way. And that's because it's the expression itself that has been memorized, not the underlying concepts.
Interesting. Yeah. And that's also, another thing that I did is I went to ChatGPT, and because I also heard that, it's virtually impossible for an AI, generative AI, to output verbatim the expression or creation that has gone into it. Okay, well, if it's virtually impossible, that must mean it always happens all the time. I mean, because these words, because I went and I did, much like you did, my own test, and I just asked it, like, can you give me the lyrics to American Pie? Which is one of the songs in Lawsuit right now. And it did say, well, I can't give you all the lyrics because that would be a copyright violation. But here's a verse. And I said, can you give me another verse? It gave me another verse. Can you give me another verse? It gave me another verse. And they were all literally identical to the lyrics. These were not like close lyrics. And it's like, so the output is the same. Terry, is that what you're seeing from your folks are having their output taken? Or the output is what the input was?
Yeah, I think you're very much seeing similar results to what the news media folks have seen and others. And just personally going through, I've noticed as more attention is being focused on the fact that, these models are capable of spitting out infringing outputs, and they're being fine-tuned to add these guardrails on, it's still possible to go and ask it for, the first chapter of A Tale of Two Cities or something in the public domain, and it could still spit that out verbatim, which to me is just as telling, because that's showing that, yes, this model on some level is able to recreate the expression that it trained on, not just the facts. I think there's a lot to unpack there, but I did want to just go back to something you had mentioned about some of the AI developers who are really pushing to say this is fair use, to say this isn't copying expression, and even saying there's no infringement at all. I want to be clear that we're delineating between, the kind of the threshold issue of was there copying of protectable expression, and the second issue was if there was copying, there is fair use. Because I think the issue is properly a part of the fair use inquiry. I don't think there should be any credence to the argument that there's no copying that implicates the copyright owner's exclusive rights at all. Because there's no distinction in the Copyright Act that says you're infringing if you only copy expression. I mean, it just says, here's the exclusive rights, reproduction, creating derivative work, translating, recasting, and anyone who violates one of those exclusive rights is an infringer. And so, just period, that's the infringement inquiry. All the work will be done in the fair use analysis. But I've seen, there's sort of muddying of those waters there to really call into question, the fact that there is copying of expression that results in, very real harms to copyright owners.
Yeah, there's a lot of muddying, and we're going to go into that even more here. But John, before I ask you any specific question, do you have anything that you want to react to that's been said so far?
Yeah, just a couple additional things. One of the reasons that I started focusing on visual infringement was because it was so easy to demonstrate the kind of issues that you see. So the early examples from the Getty litigation, where essentially the AI was trying to fudge out the watermark on their images, was a really telling exhibit. From the publicity rights standpoint, if you ask most of the models for a picture of Wonder Woman, you get Gal Gadot's image. So you see that it was trained to learn, and it recorded that individual's version of that comic book character. So you have both the copyright in the comic book, but you also have the rights of publicity in the performer. And the same thing is true for Robert Downey Jr. and for Evans and so on and so forth. So you see that quite a bit. One of the reasons that, as Terry said, there is this intentional conflation of copying and fair use is because, generally speaking, and again, there's always exceptions, but generally speaking, fair use starts with the manipulation of a lawful copy. And the problem is, with the hoovering up that we've talked about, a lot of the sources that were the source materials for these large data sets were not themselves lawfully copied. Mm-hmm. We heard that earlier in the conversation that Creighton was talking about with, how do these research papers show up? Well, they show up because students uploaded them to their websites and other people uploaded them to database sets that are not necessarily licensed sets, and now they're available for a third party to sell without authorization to a data set to then use in their training model. And each one of those steps further undermines a claim of fair use. And so if you want to win a claim of fair use, you want to disclaim all of that provenance. And unfortunately, from an evidentiary standpoint, the actual litigation, who has the burden of proving what's in the data sets and all the rest of it, courts are really going to struggle with these cases.
Yeah, with the proof, from the proof standpoint?
In terms of, who has, so you're bringing a claim of copyright infringement, so the burden of production is going to be on the plaintiff. Well, the plaintiff doesn't have access to that data set. The companies are saying, we found it. And so there's, so trying to subpoena the data set is going to run into a host of structural issues. And so suddenly these are incredibly complex issues of giving evidence before the court as to even what's in the data set. Everything we talked about for the past 3 panels are going to turn into evidentiary challenges for both sides in the litigation.
I suppose, I understand what you were saying, and that seems logical. A lot of the ways that I try and predict things is like, what would I do if I were the judge? And there was this one case I found very early on in my career, and we used it all the time when there was discovery battles, because it was Sears and Roebuck. They had, for a period of time in the 70s, they sold pajamas that were flammable. And they knew that they were flammable. They knew kids were dying or getting hurt and seriously hurt and so forth. And rather than file them away in any kind of responsible way, is they filed it under the complainant's last name. And so they had literally 2 or 3 floors of the Sears Tower in Chicago was their filing system. And they had a discovery request. We want all the complaints from people who have sent you complaints about pajamas that caught on fire. Sears says that we don't have that file, but you're more than welcome to come into our location and spend as much time looking through 3 full floors of files to find the information you want. And the judge said, no. Your inability to maintain records in a business responsible way does not put the burden of this on the plaintiff. So I wonder, it will be some interesting legal battles, but it seems to me that if you could go and you say, look, hey, here's this news story, Verbatim is the output. Where did they get it? They can't tell us where they got it, but I know that they got it somewhere because this is it here. I would hope that the judges would use some of that kind of shifting. We'll see. What thoughts, any of you about that?
Well, this might take us a little on a tangent, but on the discovery point, one of the proposals that we've put forward that was in the comments we filed with the Copyright Office is to create a administrative subpoena where a copyright owner, because one of the problems you have in bringing suit against an AI tool is you don't know what they use to train the model, and in order to plead a case for copyright infringement, you have to cite with some specificity what copyrighted works are at issue. And so you have this chicken and an egg problem. And so one of our ideas is that there be a administrative subpoena of sorts, that if you come forward and say we have a good faith basis to believe they used our works, that the other side would have to hand over a list of what they used. And if they didn't, either because if they don't turn it over, either because they're non-compliant or they haven't kept the records, then there would be a rebuttable presumption that you're right, that they used your stuff. Because otherwise you just end up in this sort of endless, dog chasing its tail kind of loop.
Yeah. There's so much there. One of the other things that I've heard, and I'd like to get you guys to comment on this, is, and this is why I think, Terry, you said that it gets muddy, right? But I heard somebody tell me that there's people that think that the output from the AI can't be infringing because it can't be a derivative work because AI can't make a work. And at first blush, it sounds like it's said in a way where, like this person has explaining copyright law. I looked, the word work is not defined in the act. There's derivative work, there's, and there's other kind. And the other thing too is though it doesn't need to be an original work in order to be infringing. That's sort of the point, right? You're saying it's not original. A lot of times, sometimes it's derivative work, and they could protect that. But there's no requirement that I know of. Do any of you know that in order for it to be infringing, it has to be a work? And because the Copyright Office won't give a copyright to an AI, therefore it can't be infringing? I mean, have any of you heard that argument? Number one, you've heard that, John?
Yeah, it's coming up in a number of contexts. Including in some of the discussions of what's going into the ALI draft for copyright. That's kind of where this notion got its first hearing. So if it's not a derivative work, it's simply a copy that's a poor copy because it's a distortive copy. And so we just need to have new words like it's a distortive copy rather than a derivative work if there's no authorship that's creating that change.
Right.
Yeah, I agree. I think, it's conflating sort of the copyrightability standard for derivative works and the infringement standard for derivative works. I would just add, logically, it would kind of turn the Copyright Act on its head if we did accept that. You could imagine, say you ask ChatGPT to translate, Harry Potter into Spanish, and it did, and under the logic, well, that's not infringing because the AI made it, and so there's no copyrightability. And then you ask it, now translate that back into English, and now I'm going to sell the sort of the bad copy, but still an English copy. It wouldn't make sense that you'd be able to sort of circumvent copyright in that way, just through kind of laundering it through an AI that couldn't copyright it. It's still infringing, though.
Well, and it also just ignores basic copyright law, right? I can't get a copyright in your work, right? Because I didn't do it. I'm not the author, right? So following that line, that would then mean if I copied your work exactly, I can't get a copyright in it. So therefore, it can't possibly be infringing because I can't get a copyright in it. And it's just like, well, geez, if they do that, we just have to go home and give up, right? And maybe that's a good question to bring up right now. It's like, at what point in time do content creators just say, you know what, I got to go home? If Google can copy 20 to 30,000 lines of code, and that's a fair use, and if this winds up being a fair use, how much more can creators take? And maybe, Terry, that's a good question for you, because I know a little bit about how low paid, like novelists and novelists and writers are. These are people that create and are at or below the poverty line. How much more can be taken from them and before we don't have anything to take?
Yeah, I mean, it's the question that keeps me up at night. And I think there's a lot of ways to think about the risks of allowing sort of, AI to have free reign over copyrighted works. On the trade publishing side with authors of, say, fiction, nonfiction, one of their biggest concerns is just the fact that these models that have been trained on their works are capable of spitting out works that compete with their works. Maybe they aren't infringing, but they're, similar works in the same genre. And the problem there is because it's so easy to pump out these works, you could start flooding the marketplace with low quality AI created works that just crowd out the actual authors. I mean, it's hard enough for an author, especially a new and emerging author, to really, get their name out, market their books, before AI. And now, you're in a world where, people could generate, with the push of a button, just umpteen books, and even if no one's buying them, they're taking up space on search results. They're taking up space on like Amazon's webpage, and just again crowding out the actual authors. I mean, I think Amazon Kindle, because of this, because they have the self-published platform, put in a limitation in response to AI-generated works where you could only upload 3 books a day, which I don't know any author now who, was anywhere close to being able to do that. But even that, that low number is still, beyond what we could think of a human author creating. But it's still, needed, because otherwise, you're taking away the opportunities for human authors to actually be able to reach their audiences. And I think you're really degrading the reader's experience too, because there's only a certain amount of frustration you could put up with if you're like, I need I want the next romance book, and you go through and it's just search result after search result of poorly generated AI works. Maybe you'll find a new hobby.
Yeah. Reagan, thoughts about that as it pertains to journalists? I mean, because it costs a lot of money to cover the news. That's why so many people have, and cable news is, I think, far more opinion-based, and they do news. It's not to say that they don't do news, but opinion's a lot cheaper, right? I mean, it's already a difficult business to succeed in. What is this doing for your content creators?
Yeah, it's a really significant threat because it's an industry that already is sort of dedicated to making content available to a wide variety of readers, cheaply. Sometimes it's advertising supported. I mean, there's different models, but they're also smaller types of businesses and entities. It might be local news, or it might be subject matter specific. And you can get your news or your media from a variety of sources right now. It's not on the other side where you have just a few platforms that you might go, or even the grocery store. You might be someone who always goes to Giant or whatever. But in the case of the newspapers, we have about 2 closing a week. And a phenomenon of what's called news desert. So a lot in rural communities or underserved minority, or urban communities where you're not getting access to reporting to tell you what's happening in your local community, as well as even some of the larger companies are facing threats and have had to reduce some of their staff, because you're right, it costs money to invest in journalism. There's coverage decisions, there's fact checking, there's editorial corrections policies and procedures, and all of that costs money to create. And so our Constitution has this idea we'll have a free press, but we need to have a press that is flourishing in order to sort of fulfill the promise of what our society is about. So on the other hand, I think part of my other thought from what Terry was said was some of these uses of taking content to create something that floods the market and competes with it. I mean, that to me just strikes me as something that is beyond what our laws have found was a productive use or something that would be a fair use. And so if we were to look at how our existing law and how those line of cases go, that actually would make me feel better that these cases will start to come out the way that respects those sort of traditional lines, because what what you're talking about is a concerning phenomenon, but it's not something that we've ever said, oh yeah, that's fair use in the past.
Yeah, and see, that's the thing is I see a lot of the arguments being made by, and I get it. Like, if I was representing the AI developers, I'd be making all these same arguments too, right? I know what they need to argue if they don't want to pay you, right? If they don't want to pay you, this is the stuff that they have to argue. So I get it on some level, but this whole fair use issue, the law doesn't need, we don't need, I don't think, new law to tell us that this has to be wrong, right? I mean, one depending upon what case you read and when you've read it within the history, either the damage to the market is critically important, highest and most important factor, oh, not all that important in this case, but it's got to matter, right? And they're taking it away, seems to me, from you all your creators on the front end by just collecting it wherever they can get it and feeding it to their system, not paying you any licensing royalties for that right. And then they are taking away, as Terry said, on the back end by having it be either the same output, so now they don't need to go to your news website or to read it, or it's so similar, or it's just flooding the market with bad stuff that it's hurting the content creators on the back end as well. I mean, if this winds up that factor winds up not going enormously in favor of the creators, I don't know what to say.
I guess if I could just say one thing that struck me in how you spoke is that on the one end, the ingestion size, like those are also licensing markets that exist. Mm-hmm. There's markets for text and data mining, in the media context. There's markets for news clippings, media monitoring, going
Absolutely.
to Lexis, going to archives. So it's not that we don't know how to do this, to your point. It's just not being done.
Right. No, it exists. This exists. This business exists, and they're circumventing. That was one of the questions, and it came out earlier. I don't know whether you all were here, and you probably know this. And it was like, how do they get your stuff anyway? Right? Are they hacking to get through, or do they go in and do they register and then abuse the terms and services that they've got? I guess. And probably there's some of all of this, right? But then a lot of it is just stuff that other people have put up and not behind the paywall or firewall or whatever. And there's this, what appears to be just this black market in data and information that's used for training, which I don't get for the life of me why, if you were trying to create an AI, you would just, John, can you share what you told me about, essentially when we were talking about garbage in, garbage out?
Yeah, my original comment was, right, so if you're trying to build a model and you're testing the model, you just ingest everything you find, and what the output is going to look a lot like Reddit, right? Because the primary source, the cheapest data, is the internet itself. And the other thing we were talking about, why the whole Musk issue and where that validation is, right? There are thousands and thousands of books written about the Third Reich and Hitler and the evils of World War II. But there are tens of millions of posts about what Elon Musk tweeted last week. And if all the algorithm does is look at correlational data, then those tweets vastly outnumber those thoughtfully researched books. So it's inevitable that your algorithm is going to have these kind of structural flaws built into it by the nature of the training models.
Mm-hmm. And Terry, I think it was you that made this point during the pre-call, this is sort of precisely why the developers really need you guys and your creators, right? Because without you guys providing good information, reliable, verifiable for these models, what are these models going to look like, right?
Yeah, exactly. I think, for exactly those reasons, you look at books, which are long form, even fiction, it's long form, it's storytelling. This is very, very valuable if you want to have, chatbots that are able to understand context and do things more than just, answer in one or two sentences. And then you get to nonfiction and you think of, again, all the kind of the factual information that goes with that. my association also represents the scientific and scholarly journal publishers. So certainly a lot of value in the articles that they publish for a lot of different use cases. So if you take away the ability to be able to invest in those types of works and you're not able to sustain those, I mean, it's bad news for my members, but it's, I think, bad news for AI developers too, because again, if you're left with having to train your models on just what other AI models have trained, it quickly degenerates, and it's not going to, maintain or improve upon the quality going forward. And just, I mean, generally, just talking about the importance of books and other, long-form media to society as a whole. I mean, I don't want to lose sight of that, given all the other generalized risks that people are focusing on with AI, in national security and in health and safety and all these other areas. I mean, books, journals, textbooks play such a valuable role in making sure that, our own citizens are able to respond and address these risks, in terms of, sifting out misinformation and disinformation and making sure, they know, when ChatGPT spits out, cases, that they know how to research that and can go to an authoritative source that, they could double check that and verify, the output from generative AI models.
Yeah. And it's, well, let me ask you, does anybody have any questions for the panel? Go ahead, Rob.
I have a comment and a question for it. At least in the context of content you can paywall, I would think, or I would assume, hope, that you could use your terms of service, your terms of use, to force a waiver of a fair use defense. But on the other hand, I'm a patent attorney by trade, and there's no way I came up with a solution to a copyright problem. So, I mean, in that context, I mean, what do you think the difficulty would be in trying to build in a waiver of fair use into terms of service? Is it a practical matter because this content is available through unauthorized sources, or is it a legal matter where even that waiver wouldn't hold up?
I could say for media publishers, there's a couple things going on. So one is many of them do have AI training or use prohibited by terms of service, and you would hope that that is being honored and respected. Some of the terms and service can be, that's not always the case, but that could be one bulwark. Another thing that happened over the summer is robots.txt, which is a protocol. You can use that. Two of the leading AI developers, Google and OpenAI, said they would honor. A lot of the media publishers began invoking that and saying, do not crawl. So it is bot crawlers that come, including under paywalls, because they need to index for search uses, but they could crawl for that purpose. The thing that is not satisfying about that is you don't always know, bots don't always knock at your door if you operate a website and tell you who they are and what they're there to do for. So you just kind of say in or out, it's one way or the other. And there might be multiple bots coming from the same source. You might not know the source. So that's really sort of imperfect when you figure out that if you're operating a media website, you also need to appear in search and indexing results, and you shouldn't have to take yourself out of that contention in order to protect yourself over use for AI training. And then you name the other sort of, imperfection, which is people use and they reshare and they put articles on social media or they put it on Reddit or in other places, and that's great. That's part of, what might be permitted through your subscription and through your, acquiring something through advertisement. That doesn't mean that it's permitted to be used downstream for AI search purposes, but that is another obstacle, as well as these literal the pile, but these large data sets where people have hoovered stuff up and put them into compilations for use in AI.
Well, and another aspect of it is a lot of times the content is available through a third party. And so if you're the content owner, you're not necessarily in charge of the terms of service, or you're not the one that's enforcing the terms of service. Or if you want to rely on that, then you have to bring a third party into your litigation or your defense.
So I'll add,
go ahead, John.
yeah, I want to add one more piece to it because I actually have done some scholarship on fan fiction, right? And so one of the, and I think I can say this, the other group doesn't, right? There's a business decision that's made about the level of enforcement for copyright infringement, right? So we learned during the Napster decade that a business model of suing your customers is generally not a great business model. And so there's a tremendous amount of copyright reuse that is neither authorized nor fair use nor enforced. And the fan fiction community is a very vibrant community, and it's a great example. Paramount, for example, had a movie, when the movie crossed the $1 million threshold and started to have SAG actors in it, suddenly the fan fiction rules were like, I'm not sure this is fan fiction anymore, this is a competing product. This was a Star Trek movie that was better than many, and I strongly recommend it. But so there is a second layer of copyright that deals with how much infringement do we want. Ironically, if the only way to stop this massive infringement is to crack down on the consumer, we create a really unhealthy cycle. And so we really need to think about the unintended consequences of allowing these explosive commercial uses on how they're going to force content owners to over-police where we don't want them to over-police.
Mm-hmm. And one of the things that we talked about, John, I like to hear your thoughts on this because I think it was you that we mentioned this during the pre-call, about the fair use used to be an equitable defense, and now it's in the statute. And if this were an equitable defense, then where they get this from, the third parties that they know have taken it without permission from you all, your members, and posted it up there, and they have blinders on, and the see no evil, hear no evil, speak no evil. That's not a defense if it's an equitable defense, right? You knew what you were doing, but how is that going to impact or play with the statutory factors, do you think?
Well, so we had fair use invented by Justice Story. And the original paragraph that explained fair use was elegant and simple as only Justice Story could write it. In the '76 Act, Congress codified the Act, specifically stated that they were not intending to change it at all, merely to incorporate it into the statute. And immediately courts started to treat it as a statutory doctrine and interpret it differently than they had as common law. And so one of the consequences of that was to increasingly drop out the equitable nature of it. And I think that's partially kind of just a history over the last 100 years. As equity and law have merged, all of the equitable common law defenses are fading from modern litigation. So it's part of that broader trend. But that makes it harder. But in particular, we haven't talked specifically about the fair use cases, but the Google Books case, HathiTrust, those cases talked a lot about facts that are different than this use, but then generalized law that has become the wide door that the AI companies are hoping to drive through. And again, that's an example of a case where the court, from an evidentiary standpoint, stripped out many of the individual books because it was too complex for the court to handle. Google and HathiTrust changed the terms of service numerous times to knock out claims and narrowed the case substantially in a way that was good for the copyright owners, but ultimately bad for the case law. But now it's being used as the evidence of kind of all of these license to copy rules. And that case ignored completely all the equitable defenses because the court really focused on, this is the technophile age, the 20-year halo of technology, and really, really said, snippet view is wonderful for me as a judge, and it's wonderful for the world, and how could this be harmful? And with that kind of simple analysis, ignored the first major data set grab that generated so much of this. It created the Google translation products. It created the early stages of Bard. Right? The Google Books massive data dump was the flag that started the modern age.
Mm-hmm. Okay. So we got about 10 minutes left in the segment. And
There's a question.
Oh, there's a question? Yeah. Go ahead.
While the litigation's playing out, it's probably going to take a while. Are there any practical tips that you're giving to your content creators today to protect themselves as in the intervening years they produce more works? Like, are there other steps other than the anti-bot technology that you're advocating that creators deploy to protect themselves?
So the question is, what advice are you giving your content creators to help themselves technologically or otherwise to deal with this?
So, I mean, for my members, and going back to kind of the previous question, the terms of service, the technical protections don't really play that big a role because for the most part, when books are available in digital format, they're not really available on, the public web per se, right? They're already, limited to authorized distribution channels. And so the source of books from a lot of, at least, the first round of AI foundational models were unauthorized sources. I mean, that was the Books 3 data set, which someone put together by going to a pirate site, collecting 183,000 ebooks, unauthorized ebooks, and putting them up online as a data set. And, in some of the lawsuits, the claim specifically alleged that they were trained on these unauthorized data sets. And, sort of similar with the other types of publishers, scientific scholarly publishers, they already do to some extent license out TDM rights or similar rights, but to the extent that their works are being used to train AI models, they're being sourced from unauthorized sources, from Sci-Hub, from LibGen, from all these pirate shadow libraries online. So, to some extent, yes, I think the companies themselves, for the most part, are sophisticated enough to try to implement technological protections, to try to use the emerging, do not scrape standards that are being developed and already available. But a lot of it, is just really following the litigation closely. I can't speak on behalf of any of my members, but I do know generally a lot of them are being approached by model developers, maybe not the leading ones, but sort of that second tier, the newer entrants for licensing discussions. So I think that's happening, and that's where where they're sort of focusing their attention is figuring out what their views are on licensing and kind of what's emerging in the marketplace there, and to the extent they want to license, that's, I think, the best solution for copyright owners as a whole is to develop the licensing market for training, and both because I think that will make the whole enterprise work, but also when we're talking about the fair use litigation, to the extent plaintiffs are able to point courts and show them, look, there is a marketplace here that's being harmed by the unlicensed use for training. That's just going to help out on the fourth factor in the overall fair use analysis.
Yeah, absolutely. And I guess the one thing in the time that we have remaining, I'd kind of like to just get your general thoughts about, and this maybe applies to copyright law generally, is, and for a patent guy, I know copyright law quite a bit. I mean, I make my business is content creation, right? And I was in the independent record label business a long time ago. So I've been in the copyright industry for a very long time. And I just find it impossible to understand these cases or where people think that this is going to go. And I think a big part of the problem that the developers is, for every case that makes sense, there's cases that don't make sense, and there's, like, in the music space, there's the George Harrison case where there were 7 notes, and that 7 notes wound up being copyright infringement, you know? And then you take 20,000 lines of code in a Google case, and well, that's fair use. And it's like, how can both of those things exist? How can taking 20,000 lines be fair use, but 7 notes be infringing? It would seem to me it ought to be the other way around, if you're gonna have it, one or the other. And do you sense that a lot of the incongruity of copyright laws in general, and maybe not the law, but the cases, is facilitating some of these arguments?
To your second point, I think a little bit yes, and I think that's what John was talking about, is I think there was a time when the courts they really kind of doubled down on transformativeness, and the Andy Warhol case really kind of right-sized what transformative use is all about, and and I think that heralds a much better day for fair use litigation. But on the question about the 20,000 lines of code or 7 notes, I think that is fairly consistent through the case law, which is that where you get into functional software code, the courts have fairly uniformly treated that as less protectable than highly creative, expressive works like a song that George Harrison wrote. And I think when you get into some of the case law, like the AI developers like to cite a bunch of intermediate copying cases which involved functional software, and I think that's part of the weakness of those arguments, is that they're relying on cases that involve functional software, which has a much lower level of protection, a much thinner copyright. And I think when you're dealing with highly expressive creative works like sound recordings, like musical works, like journalism, like books, I think the courts have tended to protect those much more strongly.
Okay, I mean that's as good an answer as I think you can have, right? But this is not the intermediate or copying or interstitial copying cases. This is taking wholesale databases, processing them to train, and then having that which was trained have the ability to output exactly what was input, among other things.
Right, and that's exactly what the Warhol case said was a no-go, that when the output is going to substitute for the input, that's not fair use.
Right, right. Okay, so we have 2 minutes left. So in rapid fire, I want to give each of you a final thought. And while you're thinking about your final thought, I'll let everybody know this was a CLE panel. Reagan mentioned the white paper that's been linked to the panel URL page where you can get that and other materials that will make up the CLE materials if you need CLE. But I'd like to get your parting thoughts. And I always like to ask if there's one thing, and hopefully people remember a lot more than one thing, but there's one thing that people remember from this conversation. What is that one thing? What do you want it to be? John, let's start with you.
Sure. So for me, it is not the threat to today, it's the threat to tomorrow, right? To me, the world doesn't end with the Terminator, it ends with WALL-E, if you remember the Disney movie, right? So if we cut out the backlist authors, the second-tier musicians, because the superstars will continue to make a living using publicity and trademark, but we don't train yeoman artists to make a living as professionals. We'll have a lot of first-time creators because we still have an instinct to create, but we won't have trained professionals who hone and build their craft. And when we lose that generation, the next generation will have no role models, mentors, or anyone to help them. And within 2 generations, we have collapse. And so it's really essential that we recognize that artists need to be developed, they need to be invested in, and they need to have mentors and role models all the way down the catalog so that the system works. And if we gut the middle, then the system will ultimately fail.
Great, thanks, John. Terry?
I mean, I couldn't say it better myself, but I mean, I would say in parting, we have to remember that this this is a global issue. And think internationally. It's not just what happens in the U.S., it's what happens across the globe. Every country is thinking about these issues. And I think it's a point of pride that the U.S. creative industries are some of the leading creative industries in the world. And that's due in large part because our copyright laws, our IP laws, are able to protect and foster those industries. And so with that in mind, I would hope the U.S., our Congress and our courts will remember that role and serve as a model for protecting the creative industries in the future, and not allow them to be compelled to subsidize AI companies that ultimately will, as John said, will ultimately lead in just a dimmer future.
Yeah, great, well said. Thanks, Terry. Reagan.
I guess I would say when we're talking about fair use, we shouldn't get too sort of tripped up in the different cases to try to feel like we need to justify a use that's fundamentally parasitic. Like if it feels icky, it probably is because it is parasitic and it is not likely to be fair use under our existing case laws. We have centuries of cases. We have Justice Story himself. He's talking at a case about abridging a biography, and that's what Folsom versus Marsh was about. The very first copyright law in Connecticut was set up to protect Webster's dictionary. So these are sort of what our law was designed to do, and I think Susan kind of scratched the surface, I thought, in a great way of how these technology cases have come out to do something different for functional uses, which is not really what we're looking at here at all, versus taking a little bit and competing with it. It's not necessarily the hardest case in a lot of the instances we're talking about now.
Yeah, I would agree. I don't think this is a difficult case. We'll have, as John mentioned, some difficult procedural issues and T's that need to be crossed and I's that need to be dotted. But I think fundamentally, a great way to think about this is parasitic. And if this is allowed, then, Katie bar the door. I mean, it's just Pandora's box has been opened. So thanks a lot, Reagan. And the last word goes to you, Susan.
Well, I agree with what's been said before. The copyright industries are very important to the U.S. economy. They're a big export. I agree with what Reagan was saying. It's commonsensical, and I think judges and courts ultimately get that, and I don't think they're going to buy into a lot of the AI arguments, which are really just kind of doublespeak and spin, and trying to use sort of linguistics to make try to turn common sense on its head. And I don't think the courts are going to fall for it. And if they do, by some chance, I think Congress will see the harm.
Yeah, and that's where I come to this. I mean, I have never been so confident in predictions I made. This can't be fair use. It just can't be fair use. And if for some reason, some judge convinces himself or herself that it is fair use, then Congress is going to step in. They have to. When you look at what content creation means to our economy, we can't possibly, it would be probably the largest shifting of wealth from one end group to another if this winds up being fair use. I mean, the creative minds and the writers, they mean a lot to us, not just society, but a lot to us economically. And we need to protect them, period, the end. And I apologize to nobody for thinking that they need stronger protections, not weaker protections in today's day and age. So thank you for a wonderful conversation. I thought that was fantastic. Thank you.